How's it going, Peter?
Hello, sir. How are you?
Thanks for joining us today. We really appreciate it. For those of you guys on the line, this is going to be on legal structuring for real estate investors. So, as you guys know by a lot of our events, we just teach here. We don't sell anything. We purposely try to go through and bring out quality education for real estate investors, and in doing so, we get a ton of relationships that we work with on a consistent basis. My name is Matthew Owens. I'm a California licensed CPA and a full-time real estate investor. We flip about 10 houses a month, invest in multifamilies, promissory notes, and syndications, and we act a lot like financial advisors as far as helping clients with their individual financial situation and their real estate goals. That being said, I also run the Phoebe Long Beach and Phoebe Manhattan Beach, which stands for Investors by Investors. It's a nonprofit organization that teaches financial education and real estate education without the boot camps and the book and tape sets and things like that. And our company is OCG Properties, and what we do is invest in real estate with all of those other avenues that I just discussed. And we try to teach people the right way to invest, because there's a ton of false information out there in multiple areas of investing. And specifically when it comes to the law and legal sides, which Peter is very well versed in. He's my attorney on the syndication side, helps a lot and helps me with a lot of my contracts. He's always a great ear that will listen to my wildest schemes that I come up with, and say, hey, Peter, how do we handle this thing? And he gives me the right structuring, the right tools to do so. So I appreciate him very much, and I feel like he's a wealth of knowledge to learn from tonight, and that's why he's on the line here. So I remember the very first time you helped me with a joint venture structure, Peter. You actually sat down with me and went over every single clause of that agreement so that I understood it in detail, because it's so important for me to know it so I can explain it to my clients, because I'm going to get a billion questions out of it, of course. And so I always felt that was going above and beyond what any other attorney has done for me. And maybe that should be normal, and I think it should be, but so that clients understand it. But then at the same time, I felt that I didn't ask for that, and I was actually pleasantly surprised and shocked by it. I still remember us sitting at breakfast when we were doing it too down in. It's always great. We could go down to Manhattan Beach and have breakfast and go over documents. So the fun things a CPA and attorney love to do, right? So, but that being said, I'd love to give everybody a little bit of feedback on your background, what your specialties are, what you focus on the legal side, and how you help clients out.
Absolutely. So hope everyone's having a great evening. As Matt said, my name's Peter Fisher. I'm an attorney, a shareholder with the firm of Enenstein, Pham & Glass, which may be a little different than advertised. There was a Lavinia and a Ribicoff in there. We've changed our name, I think, since the broadcast went out. I'm a real estate lawyer. I'm actually a real estate and corporate attorney. My sweet spot is really the intersection of real estate and corporate syndication, securities, joint ventures. We do everything from purchase and sales, all of the dirt stuff as well. But my specialty is really in syndications, private placements, capital partnerships, and things like that. All the things that Matt previously mentioned. The firm itself is a full-service firm. We do a lot of litigation. We have actually a 4-person family law department. If I go to court, it's a bad day. I don't get involved in any of that. My practice is purely transactional.
Good, because the ones that go to court have a really bad reputation. So it's funny. I like to give him hell for being an attorney. I do that to my grandfather too. I always tell him that the CPA exam was much harder than the bar exam. And he said, well, you don't have to go to school for 2 years to become, or 4 years, or whatever it is to become a CPA, So you just study for the exam, So, but thank you very much for that, And I think one of the things I like best about when we talk is the kind of the straightforwardness of our conversations and telling me straight up, hey, you know what? If you're going to do that, you have to do this, this, and this. And hey, someone told you to structure your entity this way, or set up this entity because of this asset protection strategy or this tax strategy, and you kind of break down the reality as to what's happening there and the reasons behind it. And I think that's the most important thing, that education from the legal standpoint that really helps your client succeed and be able to duplicate this process over and over again for, future investments and not make the same mistakes a lot of these investors make. So, for example, just one of the things that comes off the top of my head is there was a big scam a while back that I had heard about that I know a lot of people got involved with, where there was law firms saying to California investors, go set up your entity in Nevada and you don't have to pay your $800 taxes, and it's more privacy, protects you more, and things like that. And it's interesting when you find out that there's really not much truth to that at all. And that people, some really bad attorneys will give good attorneys a black eye because they try to teach the wrong things, or they're in it for the money. And I think that that goes with every industry, right? You have accountants that will not share 15 minutes of knowledge that could save somebody thousands of dollars because they don't want to they want them to pay for tax planning instead, right? I mean, there's always going to be the bad apples, and it makes me appreciate the good ones like yourself. So, getting into that a little bit with the legal structuring, and today we're going to be talking about the mostly related to real estate, but also as it relates to business, because that's what we're doing. If you're flipping, you're running a business. If you're holding a bunch of properties, you're running a business. And most strategies you're dealing with are not necessarily just passive strategies where you're not actively involved. Everybody should be actively involved in their investments to a degree and understand them, and not just put their money in stocks and mutual funds and just let it sit there and pretend like, it's all hunky-dory, right? So one of the things I want to start talking about is the different structures that do exist, and how different investors can use those in different ways to protect themselves from a tax as well as a legal standpoint. And so let's talk about, I guess we'll start with asset types, and then how we might protect those types of assets just on a general scale. And obviously it's going to be different for each person specifically. I think in addition to the asset types, we should be talking about what's the reason to form an entity in the first place? What does it do for you in the first place? And I think that's probably the starting point. Is what are the reasons why you see investors coming to you that they want to set up specific entities for different parts of their business?
Yeah. So one of the things that I'll get it off my chest. The first thing I'll say, you'll hear me say it depends a lot. And that's because every situation is different. And I think, you hit the nail on the head when, the first thing that when you go to an attorney, that attorney should do is sit back and ask a lot of questions and listen to the answer. Because certainly, forming an LLC is not right for everybody or every deal. Forming a corporation, might be great for a startup, and it might be the right thing that a venture capitalist will only invest in a Delaware corporation, but maybe totally wrong for something else. So every situation is different, and some lawyers like to feel like they're smarter than their clients and they know all the answers, but by listening to your client or potential client and learning exactly what it is they want to do, and their level of sophistication, their tolerance for time and spending money, and all of those things will, lead you to one answer for one person in one deal and a totally different answer, maybe the same deal for somebody else. But so, basically the reasons that you want to form an entity are, number one, for liability purposes. So if you're buying a house, if Matt goes and buys, an investment property, and a contractor saws off his hand, and that's in Matt's personal name, obviously, there's all of Matt's personal assets, or whatever is in his personal name would be available for a potential judgment. If that house was in a separate entity, an LLC, would be confined to, if he's talked to somebody like me and had separate bank accounts and followed the formalities of what you need to do for that entity, you would be limited to the assets of that entity. You could also, of course, have insurance policies and other things. But so one purpose is to limit the liability of what goes on in, the house owned by that entity or whatever the asset is. Another main purpose is to have a vehicle by which you and one or more partners can figure out how you're going to govern cash flow coming in. You're going to govern decision-making process. So if you and I have a lot of money, and I say, wow, Matt's an expert. He's going to go buy a house. I want to fund it. Instead of me just handing you a bunch of money, obviously maybe we form an entity and we have a governing document, and it says Matt will make all these decisions, but if he wants to spend more than $100,000 on any one thing, he's got to come talk to me, on decisions of when to sell, all these kinds of things. You have an entity that you and I own together. Maybe, I want to sell my share to somebody else, and, we can transfer it, and all those kinds of things, are possible if we form an entity together.
So you're talking about the two primary things to start are liability protection and forming partnerships where you have an operating agreement which outlines all of the details of the partnership in great detail, right?
Yeah. Partnership, control, maybe we put money in a bank account that is separately owned by that entity. So
okay.
That plus, limiting your liability, I think, are sort of the two main reasons to form an entity.
Okay. And I think the third one would be the tax mitigation piece and, setting up trusts and that kind of thing for, estate tax purposes or probate purposes and things like that. But, from a real estate standpoint, we're primarily looking at, the liability standpoint, right, and partnerships, because partnerships are huge, and it's interesting how many of them go wrong if that's done incorrectly, and someone doesn't understand all of the provisions of the operating agreement specifically.
Yeah, and I think there's various tax pieces to various entities, and double taxation of a corporation. I'm sure we'll get into all of that, but at a sort of general level, I think you've got liability protection and formation of a vehicle for you to form a partnership or take in investment from multiple people, which obviously people aren't going to want to, and you don't want people handing you their own money personally,
right?
Both from a liability perspective and separation of bank accounts and control and management and those things.
Okay, so you could structure these things any way you want, depending on the needs of the partnership. Okay, and so I think when we're looking at any specific situation, I think some of the main things we have to look at is someone's net worth in the first place. So say someone comes to you, and I guess it's best explained in maybe a couple of different examples, right? If someone comes to you and owns a couple of rental properties or maybe one rental property, and has 10 grand in the bank account or 20 grand in the bank account and makes 50 grand a year, versus someone that comes to you and has $10 million and multiple properties, I would think the entity formation advice would be different between the two clients, just because on one person you have a low net worth client with not a lot to protect, and on the other side you have a really high net worth client that could be considered a target, and you want additional asset protection from that standpoint. What would be kind of, I guess, the initial thoughts that would go through your head when you're looking at that low net worth client, as far as the reason to set up an entity in the first place, or or what the kind of, I guess, liability concerns would be for that client versus this client?
Right. And it's not necessarily just low net worth versus high net worth, but you may have a high net worth client who has done a lot of asset protection and doesn't have a lot of assets in their own name in the first place.
Okay.
Or you may have somebody who is just starting out but has a really great insurance policy. So again, it really depends on their situation. And maybe you would go to some attorneys and they would say, oh, you have 4 rental properties. You have to have them all in 4 separate entities, and those 4 separate entities have to have 4, individual LLCs as managers in case one of them gets sued. And that may or may not be right. The point of the entity, as far as liability protection, is to protect what's inside the entity, right? So if you have an apartment building that you buy with a bunch of investors, you want, those investors to be protected and the building to be protected, but it's also to protect what's outside. So obviously you don't want your other assets to be commingled and to be available should there be a judgment.
Right.
If you have, two rental properties in Memphis, which are, you tell me what, maybe $50,000 each or something. You live in California, you have a lot of other assets, but you own those two in Memphis, and you say, well, I could own those two and form two different entities and, pay Peter a lot of money, or form one entity and get a great insurance policy, and, those two properties compared to my general overall net worth, not worth putting them each in a separate entity. So that's the kind of analysis, but maybe you're buying apartment buildings, or maybe those two properties, you have different investors in each, so you would want them, to be in it. So it really, it depends.
I think it's important to understand that difference, right? Is, some investors, I think, would be perfect to just get a really good insurance policy with maybe an umbrella policy, and they might be good if they don't have if they're not worried too much about the risk of that specific property, or, one or two small investments or something like that. But you also have to look at the clauses in the insurance policy to see what's excluded, and that's really what your risk is. And I think it's a personal choice, right? That's, in some of these situations, is someone too afraid to hold it in one entity, and maybe they don't understand the real risks there that exist, right? About a slip and fall happening from a tenant and suing you or something personally, or, if it's inside of an entity, then they technically can't get to you unless you break that corporate veil. But I think it's a math problem too, right? Because you got taxes, a tax return for that entity. You have the legal setup costs, which really they're not substantial in comparison to the ongoing costs that occur. You have the state, $800 fee if you're in California, for example, or other state fees if you're registering in other states. They might have a statement of information. You might have some bookkeeping costs or something like that. So it might cost you, $1,000 to $1,500 a year just to operate that entity in the first place. Does that make sense to you? I think we lost Peter for a sec. There he goes. Came back. Did you hear me? Can you hear me, Peter?
Now I can hear you. You okay. Froze up. I don't know if that was true for everybody, but you're
okay.
back.
Well, so you froze on my side, so it might have been the webinar. Basically what I was saying is that, in certain cases, it makes sense to have, just a liability policy and things like that, but it depends on their individual situation and their own comfort level associated with that specific that specific strategy, because it might cost you $1,500 a year in LLC costs just to keep it running on a consistent annual basis with tax returns and LLC fees and things like that could exist. So in my eyes, it's like, what's the risk? If I go spend $1,500 a year, but I only have one small house that's making me $300 a month in cash flow, and I only have $20,000 in equity in that house for them to go after, maybe it doesn't make sense to have an entity for that one specific property. And also I'm considering, am I high net worth where someone could come after me above my insurance policy and my umbrella policy as well? Or am I really not at risk of losing a whole lot, from that standpoint?
Well, yeah, and I think you hit the nail on the head, right? I think one of the things that, you should also be considering when you're talking to a potential lawyer is, look, it's great that somebody has a lot of legal knowledge, but you're running a business, so they gotta understand the business side of this too. Maybe you're an experienced operator, you're buying a number of properties, you know how to pick the right tenants, you have renter's insurance, so you're reducing your risk that way. You have great insurance. You don't want to buy, a package from a lawyer who's going to say, okay, I'm going to form 8 LLCs for you. You're going to have to file. You're going to go to Matt, somebody else. I think I've told this story at Phoebe and other, events that we've done together, but I represented a client once that had 8 individual sort of 12 to 15 unit apartment buildings, all in her personal name. I don't think she may have formed one or two LLCs, but certainly, didn't take the advice of countless attorneys who said form 8 individual, LLCs, make sure these are all separated. She had great insurance, but even more than that, she had done it many times. She knew how to pick the tenants. She knew when there was a problem, how to handle a problem tenant and get that person out without a lot of fuss.
Right.
She was invested in, Long Beach and the same area, so she knew the area. She knew the profile of the neighborhood, and she retired and went off to Mexico and didn't need to have somebody like me tell her that she needed 8 LLCs, where somebody who's just starting out, 1 or 2, maybe they would want that, especially if they're bringing in capital partners, let's say.
And I think people's determination internally, whether they want one or not, may also come down to what their experience has been in the past. I mean, there's shysters out there that will target you specifically, and they're not always out there, but at the same time, if it happens, guaranteed you're going to go and put an entity in place for the next one. So and I think in a situation like that, it could have cost that lady $7,500 to $10,000 a year in addition, and separate LLCs or more, just to have that structure set up for that proper liability protection from the corporate veil. And can we talk about that corporate veil really quick? Because I hear and I understand it myself, but for the audience, can you kind of explain some of the ways or what attorneys are going to do in a lawsuit, what they're going to look at first when they're trying to see if you pierce that corporate veil or not? What do you have to do as an investor when you have an entity to make sure you're protected and it's not pierced on that side?
Yeah. So the idea of going through the process and paying somebody like me to form an entity and set it up correctly for you, right? The base, what we said was, so you limit your liability, you have liability protection. But in order to do that, you need to also understand what's called, potentially piercing the corporate veil and the corporate formalities or entity formalities of what you need to do to keep, yourself protected. So you have to make sure that this particular entity has its own bank account, its own tax ID number, probably. If it's a certain type of entity like a corporation, it has the right officers, the right directors, the right number. You hold the right meetings. So all of these things, and I know we're gonna maybe talk about LegalZoom and other types, and people who aren't sophisticated and experts in corporate formation and general practitioner lawyers or whoever, it's not just knowing how to put together an operating agreement, knowing where to file it. It's knowing what to do after that and how to, advise your clients on, okay, wow, you have 3 companies, make sure they don't all have one bank account. Make sure that all of these people are actually, if you're in a corporation in California, you have the right number of directors, you're having shareholder meetings, you're having, etc. And all of these things, if you don't do them correctly and something happens in that entity, and I apologize for my phone, but, it's going to, a smart contingency lawyer is going to come in and say, wow, this is a sham entity because you didn't really keep it separate from your other businesses. It's the same thing as you because you never had meetings. You never, put the money, you shared your personal money in this entity. So all of those things after the entities are actually formed that you also have to pay attention to.
Okay. And I think it's important also to understand from the initial formation purpose that you want to understand what state you're trying to do business in as well, because there's definitely different laws in different states, and there's a tax differences in different states. For example, in Tennessee, if you have a Tennessee LLC, so there's no state income taxes in Tennessee unless you own property in an LLC. However, and if you own it in an LLC, you owe a 6% franchise tax. However, if you put it in a Tennessee specific LLC that's formed in Tennessee, whether it's registered in California or not, to form it in Tennessee, then you basically, and it's 95% family owned, then you can qualify for what's called the fonts exemption and then not pay any of that tax. So each state has little quirks like that that you want to be careful about when you're forming in those states specifically, you know. And so, like, and if you live here in California, they're gonna want you to pay the $800 fee no matter what. So you should be, if you live here, you should be registering that entity here, even if the asset is in a different state. Does that sound right to you?
Yeah, I mean, you might think that if you are doing business in California and you're buying a property in California, that clearly that means you want to form in California. Or, if you're buying an asset in Memphis, you clearly want to, buy and set up a Memphis entity. Which is not necessarily true because, for example, in California, if you're forming an LC, there's a new LC Act, which they ostensibly formed to try to clarify and streamline things, and it made things much worse. Surprise, right? Fiduciary duties, what member consent is required. I mean, that could be a whole other webinar. But the point being, we often recommend that clients form, especially if they're bringing in investors and you're managing a specific asset here in California, you might form an LLC or an entity in Delaware because the laws in Delaware on, fiduciary duty and management and things like that, they're much more friendly. Reason, right, that all of your big corporations are, formed, in Delaware.
Right.
So there's reasons why, but then again, like you were saying earlier, there are reasons why you might not want to go to somebody who says no matter what you got to form in Nevada or Wyoming because the taxes are lower. There's anonymity. Well, if you form in Nevada and then you're doing business in California, well, guess what? You still have to register and qualify in California. You still have to file a statement of information with the information you were trying to keep anonymous in Nevada. So,
right, and then you're screwed anyways. You're totally exposed. Okay, that makes a lot of sense. And so when let's talk a little bit about the entity piece really quick. And most people have an understanding, and tell me if I'm wrong, that normally if you're holding rental property, you're either holding it in your own name or typically an LLC or something along those lines. So that it's a flow-through entity for tax purposes in your own name, and you can mitigate some of the risk associated with owning a piece of real estate or a property in that case. And we had a question here that someone asked about, they put an LLC together and they're trying to get a loan from a bank, but they couldn't get the loan. And a lot of times, 90% of banks, if it's traditional loans, will not allow you to get the loan in the LLC's name. You have to do it in your own name first, and then transfer ownership to that specific entity afterwards. And you're not transferring the beneficial interest if you own that entity 100% yourself under the due on sale clause, or at least that's what I've heard multiple times from attorneys and things like that in the past. But you have any comments on that by any chance? Or?
Yeah, I mean, one thing I would say, a lot of times that is a trigger for a due on sales clause, and you're right. A lot of times, especially when you're first starting out, you will have to get a loan in your own name. That could be something as simple as talking to your banker and getting somebody like me involved who can understand and speak that language and say, look, yes, he's going to get it in his personal name, but let's put an exemption and draft some language around the due on sales clause that once you put it in this LLC, bank, you shouldn't care because it's going to be personally guaranteed anyway, something like that.
Right.
It is, and a lot of times you could put it in an LLC and the bank, that they may not notice, or B, may not care if it's, still ultimately you, and they're not going to, you're paying a loan. They're not going to all of a sudden say, oh, you put it in an LLC, so maybe you do it even though technically, that's a default. But it's usually better to, have that conversation and try to address it up front, and not run a risk of that. But
and I know most or 90% plus of traditional mortgage lenders will not lend the money in an LLC first because they're selling Fannie Mae, Freddie Mac, and they need that personal guarantee on there and all that stuff, even though they can get it anyways. But I mean, I hear you on bringing in an attorney, especially if it's having. I mean, most commercial lenders want you to have it in an LLC anyways when you're doing commercial, a multifamily or something like that. But on the traditional side, I've never seen anybody, and maybe it's just what I've seen, I've never seen anybody get caught on the due on sale clause as long as they transfer to an entity that they wholly own, because then they have the argument at least that they didn't technically transfer the beneficial interest because they still own that LLC indirectly. However, you're 100% right. They could use it as an out. If interest rates start to rise at some point, then that's when they'd be looking at those types of things for sure to see if anybody is in default or something like that, for sure.
Yeah, and again, I mean, it's at the end of the day, there's the legal side, right, and then it's business decision. And
right.
if you're current and you have a good relationship with your bank, and you put it in an LLC, are they all of a sudden going to go and take your property? Unlikely.
Right.
And one of the things that I like to do, piggybacking on what I said before, it's all educating your client, right? Some lawyers like to not explain to their client what the documents mean and what their options are. And it's like, I know more than you, and here's how you're going to do it, and you have to form else. But, at the end of the day, I'm a businessman, you're a businessman. I'm going to tell you what your options are, and it's up to you, with my counsel, but it's up to you to ultimately make the call.
Right.
And as long as I tell you, what the potential risks are and what your options are, it should be, the client's decision at the end of the day.
Right. See, and you as an attorney can't really tell people, it doesn't violate the due on sale clause, even if they may not, enact it, right?
Right.
I'm not an attorney. You guys can't listen to anything I say anyways as legal advice. So, so definitely my opinion is that they won't do it, but that is definitely just an opinion at this point based on what I've seen, and the legality of it is something completely different that I'm not going to take liability on for anyway. So you can't listen to my advice on it. So let's talk about, when someone puts property in an LLC, what are they trying to protect against? What different liability things exist there that they're trying to protect against?
Yeah. So there's all kinds of things. If you have, let's just say, a small multifamily property, 10 or 12 tenants, and also you have, let's say, 3 friends who put money in, and you're running the property, and you're doing renovations of the property, let's say. So in any of those scenarios, you could have, an accident with one of the guys who's working on, a contractor or subcontractor. A tenant could slip and fall. You could have a railing on a stairway that gives way when somebody's walking up it. Or the property could, through no fault of your own, the market could take a dip, and investors could, not get the return that they're looking for, or heaven forbid, lose some money.
Right.
All of those scenarios are, unfortunately, potentially, places where, you or that entity could get sued. So the idea, of course, is to keep, anything that happens in that property. You don't want any of your personal assets. And if anything, the only asset that would be at risk is, that particular property.
And in an entity like that, typically the first line of defense is your insurance. Because just because you have an LLC doesn't mean you don't have insurance. You still have insurance. And then if it's big enough, if you need an umbrella policy, then they will go after the umbrella. Right. But and then it goes to the LLC, which is your shield from you personally, right? So and some of the other risks that I see are like it's all tenant risk from my perspective, as well as that construction risk. So most of the time on your insurance policies, you have to list the property management company as an additional insured, for example. And in that case, if your property manager does something that is illegal or negligent, then you could be sued, or your insurance company could be sued for that specifically as well. Now, usually in the property management agreement, you have exclusions of liability for negligence and fraud and things like that, that doesn't mean that someone is still not going to sue you as the property owner. Or if there is a slip and fall from, a contractor at the property gets hurt and they didn't have proper workers' comp insurance. They're still working on your property, and then therefore you could get in trouble or get sued for that as well, from that standpoint. And so some of those different intricacies really, mitigate the risk having an umbrella policy, or an LLC in place to stop you from those things. Because from my understanding, I don't think workers' comp type claims are necessarily covered in most insurance policies, rental policies, So.
No, that's right. And it's, something as simple as if something happens or, somebody wants to know who owns that property and they go look in the county records, it'd be great not to have a trustee that was filed with your personal name on it, but the name of an entity that's uncorrelated, to you personally. Now, if they're smarter, they have a smart attorney, maybe they can, ultimately track through the property records or find out the information. But, at least if they have to go those extra steps, then it's not just your name and your address and someone's going to come knocking on your door. That's another reason to have that entity in between.
Okay. And, other than on the rental side, we kind of talked about the rental income for tax purposes. It's all a flow through entity to you anyways. So it can be beneficial on the tax side it's like a neutral on the tax side. So that way it just flows through to you individually and on your personal tax return. So there's not a huge tax incentive at all to own it in an LLC. It's primarily for the legal liability for rental properties specifically. Now, obviously, if you're dealing with multifamily and things like that, you probably want to have one LLC per property, just because now you have a lot more tenant risk because there's just that many more tenants. Maybe some additional equity risk too, because those down payments are a little bit bigger. But from that perspective, you might be able to put a couple of single families or 5 or however many you're comfortable with based on the tenant risk, the liability insurance on each property, and your risk tolerance level, right? That's really what it comes down to. If you understand what risks are out there from the tenant side and any other side, and you are comfortable just saying, look, I'm going to have one LLC with 5 properties in there, and they only got 20 grand or 30 grand of equity apiece, so it's not very much. You want to have all these considerations that you're putting in place. And what about different types of income, like being a private lender? Do you have the same liability? We had a question about that, so that's why I brought it up. Being a private lender, what is your thoughts as far as liability from a lender standpoint? Should they be forming an LLC just to lend, or is there kind of no liability there from the ownership perspective since they don't own the property?
No, there's certainly liability from a lender's perspective. In fact, there's a whole body of law called lender liability. And you as a lender, and whether you're charging a rate of usury on depending on what state you're in, what actions you're taking or your servicer is taking when you're foreclosing, and of course, in an ideal world, if you're having a lending business, that would be done in a separate entity from an entity that might own some properties or in which you're doing another business. Because again, if somebody comes after you as a lender, it would be great if your 3 multifamily properties weren't part of the same entity and part of a potential judgment.
And that's true too. If you lend in your own name, and the liability that I can see coming up from lending has to do with the usury law, like you mentioned, or the foreclosure process if you do it incorrectly, or laws regarding lending, right? Those primary things, but not necessarily harm coming from outside. Other than the foreclosure issues and foreclosing wrong, not necessarily lawsuits against you personally for that. It would just be more, risk to your money. Does that sound right, or what's the thought?
Hard to see, for example, the tenants of a multifamily building where there happens to be a loan from X bank or X person, going after the bank.
Okay.
but certainly, there are foreclosure varies by state. There's certain rates that you can charge. People try to say, well, okay, I'll stay within the 10% rate, but I'll charge points, or I'll charge 10%, but I will, own the revenue stream. So, so those are your real risks.
Okay.
As a lender, but they are, real potential liability,
right.
For sure.
And I could imagine also in different circumstances that you have, like if I'm lending a bunch of money out of my name, and I have other assets that create liability, and it comes to me for my liability, and I have all these loans outstanding. It's they're all exposed basically at that point. All my loans are exposed in that case, which might be a good case if you are going to do. If you have other assets in your own name, that kind of changes the game. The more assets you own, because you want to separate them correctly so that way they're all protected from each other. So, and I think it's important to understand the other way around. What happens if, I own all this stuff. I have entity here for my rentals. I have my entity for my lending. I have, entity for my multifamily and stuff. And I personally go get in a car accident and kill somebody. In that case, or harm somebody really bad, and I think it's important to understand the liability at that point, because they then go through me personally liable and go after all of my assets, which I own those LLCs or those entities, so then therefore they can get to those entities through me, through liability that I caused personally?
Well, think about it this way. I own Apple stock. If I do something and I go out and run somebody off the road, nobody's going to be able to go after Apple, and that's obviously a ludicrous example.
Right.
But the point is, if you set up your entities correctly, you may own equity in X entity, you may be the manager of another entity, and yes, potentially, if you have personal liability, somebody will try to go after those interests.
Okay. That percentage of whatever you've owned in those other entities, right?
And,
it doesn't necessarily control it, though, right?
Not necessarily, right? And so those entities are, individual, breathing, separate, and if you've structured them correctly, they're separate operating entities. And you could, for example, do some asset protection, put your ownership in a trust, or step down as a manager, separate yourself from those entities, and or protect them in other ways, so that there are, and of course make sure they're, really separate, and the bank accounts are separate, and there's other potential people who are, controlling those entities, so it's not just, that LLC is really just you.
Right.
But that, that would come up, and you'd want to talk to somebody about, pure asset protection potentially at that point, rather than, the acquiring of assets kind of thing. But yes, there are ways to separate, your business interests from you personally.
Gotcha. And it's interesting. I think a lot of people don't realize the protection at the personal level as well from personal liability that you cause. So if someone's at your house and slips and falls, you may want an umbrella policy over that. And then if you're really high net worth, you should have a ridiculously high auto policy, for example. And if people are working for you or going out there and doing jobs for you as an assistant or helping you do deals, they should have really high policies that are commercial policies as well, to cover them in case they get an accident. Because what happens if they go out and get in an accident or hurt somebody, and they're going to come after you because you employed them or you sent them out to go do that job? And so I think there's a lot of people don't talk about that type of structuring, right? That I think is important. And you mentioned something as far as trusts go. We had a question on trusts and trust formation. From a liability protection standpoint, what do trusts do?
Not much.
Okay.
For a trust to offer liability protection, it has to be irrevocable.
Okay.
and I would think, it's almost unheard of in the context of real estate, unless, for example, you are, gifting a property or something like that. It is almost, most likely if you're going to use a trust structure or like you have a family trust, it's a revocable trust. And so that in and of itself does not offer you the liability protection. It's not a separate entity. You can take an asset in and out of that trust at any point.
Okay. So you're considered not owning it if you put it into a trust and it's irrevocable, meaning you can't change that trust, right? Because then you don't have control and you don't have ownership. But if that trust is maybe for estate planning purposes that is constantly changing, like a normal estate planning trust, then technically there's zero liability protection. So what you're saying the proper structure might be for estate planning purposes as well as liability protection would be to have the trust, and inside the trust it holds the LLCs or entities that hold that asset. Does that sound right to you? Or
yeah, there's a lot of
it depends, but yeah.
There's a lot of different ways. A lot of people talk about land trusts and having a trust where your attorney, a friend is the trustee, and you just have a beneficial interest. And you can use that kind of structure where you have a trust, and then the beneficial interest is let's say after the sale or purchase of a property, you put the beneficial interest into an LLC so that it doesn't trigger the due on sales clause. But again, if you have a loan, let's say on that property, the bank is going to require you to have the loan in your personal name, and you're not going to be anonymous. So, it does depend, and you've got to structure those situations correctly. And I would say, it's more uncommon for my clients to use trusts unless it's for estate planning purposes. But certainly not just for liability protection and not just for, anonymity purposes, because there's easy ways to think around those.
Okay. And what about partnerships? Are there partnerships? What are the different types of partnerships that people typically use outside of LLCs, which are another form of partnership, but an actual partnership entity? And what's the difference? And is there ways to limit liability through a partnership?
Sure. So the two main forms of partnerships, other than an LLC, which for tax purposes can be qualified as a partnership, are general partnerships and limited partnerships. And I would say easily, don't ever use a general partnership. A general partnership basically means that all the partners are liable for whatever the other partners do. And I can't think of a reason to use a general partnership as a structure.
Okay.
A limited partnership is you have one general partner who is sort of like a manager, and they are liable for the debts and liabilities of the partnership, which is why if you're going to use that structure, an LP structure, the general partner is usually another another entity, an LLC, let's say.
Okay.
That's pretty common in a syndication where you have one sponsor who forms the general partner, and then you have a number of passive limited partners.
Okay.
I would say it's less common than it used to be because now LLCs are a lot more prevalent. But sometimes for tax purposes in certain states and foreign investors, don't understand LLCs and sometimes can't invest in them. So LPs are still used. I mean, the LP structure is very similar to an LLC in that you can have, like a passive class of investors who don't have liability, just like the LPs, and then the manager, general partner who does.
Okay. And what about C corps and S corporations? From a legal liability standpoint, can you kind of point out some of the differences maybe between an S corporation and a C corp and an S corporation and an LLC?
Sure. So liability-wise, they all do the same thing.
Cool.
In that they all, have an entity and protect what's inside that entity, assuming you follow the corporate formalities. So liability-wise, generally, basically, they all do the same thing. For tax purposes and other purposes, they're treated very differently. A C corp is what's called a double taxation entity, in that the money coming in, the corporation itself will pay tax, and then once the distributions are made to the shareholders or to the members, that will be taxed again, which has its benefits. If you're a startup company and you're pre-valuation, you're not making any revenue, you don't need to necessarily worry about that. And a lot of investors, VCs and whatnot, will only invest in corporations because they can easily take board seats. There can be multiple classes of shares. There's a lot of other reasons that you should, in certain circumstances, although not typically in real estate, I wouldn't think, unless you're, an operating business, like a property management company, maybe, with lots of employees. An S corp, on the other hand, could be useful. An S corp has its own limitations. You're limited to the number of shareholders you can have, the type of shareholders. They generally are individual, U.S. citizens. But for example, when you're doing flips, a lot of times you'll use an S corp or even an LLC that can be taxed as an S corp, because you have real estate dealer income from your flips. And there's a whole, you could probably explain this better than I can, self-employed, where you might want to basically give yourself the salary and the rest will be distributed in, just shareholder distributions kind of thing.
Right. So, the primary reason from a tax perspective for the S corporation is to get rid of payroll taxes. So if you are producing active ordinary income and you're working for it, just like you were talking about as a dealer, like I'm considered a dealer because I flip 10 houses a month every month. And so that's a business to me. It's not really capital gains anymore. And so therefore I'm considered a dealer and it's an ordinary income. So if I'm making that kind of income all in my own name, then I'm taxed 15% on all of that income, no matter what my net income is. I could have $400,000 or $300,000 net income. Right, or an LLC. And so if I'm doing it in a corporation, I can do what's called the salary dividend split, where technically, and this is a general rule that applies in different circumstances, but 33% is considered salary that you have to pay yourself. So if I make $100,000, I pay myself $33,000 in salary, and $66,000 is distributions. But it depends on the required minimum salary in that industry as well. So, me being a CPA, I might have a minimum salary of $50,000 that I should be taking as, what's required in my industry. But nobody really knows what that required amount is. If you get audited, then you'll find out, So what they really want you to do is be paying a portion of your income in payroll taxes that you should be paying. And so what's cool is if you go take $100,000 a year income that you're paying now $15,000 a year on, you go put it into an S corporation, and all of a sudden you take that $15,000 down to $5,000 of income tax from payroll taxes. So from my perspective, it's active income, like realtor income, things like that. That is not, or a dealer income like myself that would be perfect for an S corporation versus an LLC, or an LLC taxed as an S corporation as well. So so let's shift gears a little bit, and I want to talk a little bit about syndications and things like that, and partnerships as it relates to securities laws and that kind of thing. We have about 7 minutes. Do you think you can cover all the securities laws in 7 minutes, Peter?
Yeah. 40, 50 years of history. Well, let's do it.
Yeah, there you go. So, when we're dealing with, private investors and raising money from outside investors and things like that, what are some of the considerations that you have to look at when you're talking about, raising money from private investors outside of a normal syndication? If you're just raising money, what are the things that you have to be careful about on the syndication side, or should research more about, since we don't have a ton of time?
Sure. So just very basically, if you're getting money from other people, they're giving you money and they're saying, "Here's my money. Go manage this property. Go." You have total control. That's a security, basically. In a nutshell. And there's a whole, obviously, set of laws in addition to your regular real estate laws, lending, usury, securities laws, which you then have to be cognizant of and think about and talk to somebody like me who's, versed in both real estate and securities. And by the way, what going back to one other point, this isn't, exactly on the topic, but when you're building your team, I know a lot of things, but I'm not a tax expert. We're talking a lot. A lot of this is tax-based, and Matt, obviously is well versed, but, you really want to talk to an attorney, but also, I love working with great real estate CPAs, and getting their opinions, and that's just another great person to have. I don't know that there are a lot of attorneys who know everything, and I certainly don't. So, I appreciate working with people like Matt and great CPAs. But going back to your question on securities, there's a whole slew of laws that you need to be aware of when you're issuing securities, because you're not just dealing with real estate at that point, but you're dealing with, equity and membership interests, and fiduciary duties, and we can have, a whole nother course on securities, but, when you're taking in investor money, you really need to talk to somebody who's versed in real estate as well as securities.
Okay, and I think that's extremely important, because people don't realize when they're raising capital that, if you're doing 100% of the work and stuff like that, it definitely could be an issue on the security side. And no matter what you're doing when you're raising money or using other people's money or doing joint ventures with people and things like that, it's important to get the right legal advice so that you don't structure it wrong and create a security when you may not need to. And one of the strategies I think works great, and tell me what your thoughts are, Peter, is just having people be involved and have management control over that entity and actually make some decisions sometimes. If you have both parties involved, your lender and you involved in that transaction, then my understanding is then therefore you're kind of around the securities laws. It comes in much more when you are the complete manager, have all the control, and that lender's doing nothing at all. Does that make sense? Or
yeah, and again, there's no bright line. That's why any particular transaction, you want to talk to somebody and not just get the answer that, form an LLC and you be the manager, and maybe in a particular situation you want the person who your JV partner who's giving you the money to have a say over, if not be a co-manager, you need to get their, consent for 12 different things. And, is 12 major things enough to make it not a security? Probably, depending on the situation, but it's 5. I don't know where the line is, but the more, control and say and part in management, the other person has, the less they can say, wow, I was totally passive. I was, counting on, Matt or whoever to make me money. They mismanaged my money. Then again, maybe, you want to go off and buy your properties in Memphis and you don't want anybody, having to, consent to, and you understand that, and it makes more sense for you to, do a securities offer.
Right. Okay, and that makes sense. And I think, from that perspective, it's interesting because when you could structure the deal to where someone has management control, but it's substance over form, right? So if someone's really not doing anything and you're doing 100% of the work, even if it's in the agreement, is that kind of an issue, or could be an issue if something? I mean, there's really only going to be an issue if something goes wrong, right? I mean, in the first place, and you get sued for it, So.
A lot of times people say, oh, well, this guy's my friend and we don't need an agreement, or we have this understanding. And, my advice is, well, if you want to keep them as your friend, you just and let's have an agreement so everybody knows and is on the same page.
Right.
As how the thing's going to be managed. What, are you going to be required to put in additional money and when? And yeah, I mean, if if you and I, Matt, form an entity and we both have co-managerial control, but you never let me do anything, that's problematic. But if we both have control and I, just go along with you, it's still, it's going to be hard for me to find a lawyer later if the thing falls apart and say, well, I didn't have any control. Well, it says here in the documents, you did, and Matt called you, and here's the record. So
right. It's all in, the burden's in the proof. And let's be honest. I mean, the best form of liability protection is how you do business with people in the first place, and how you communicate, structure the deals with people, make sure they're educated and understand, make sure that you're not dealing with people when you're raising capital that are completely clueless when it comes to money on these deals and things like that, and having the right level of education, because the ones that don't are the ones that are headaches. And I've had those types of investors, and I won't do business with them anymore because they're not sophisticated enough to handle the process and understand a process that occurs. And so who you do business with and how you conduct yourself, if you just take care of your investors and take care of the people you're doing business with, is probably the best mitigation of risk. Now, you're also trusting if you don't have liability protection in place and the right legal structure. A little too much, in my opinion, with this day and age, but at the same time, that's key. And so, one of the things that I think, we're almost done here. One of the things that I think would be key is, can you, a lot of people see a LegalZoom type thing where they can go spend $500, $800 or something like that and go get all set up, and they give you your shiny little packet and you think you're special at that point when you get your stuff in a week and a half or whatever. But from the perspective of, say it again.
More like 5 or 6 weeks.
Well, right, exactly. But from the perspective of a prospective real estate investor, or say someone's coming to you for a partnership, or what are the main reasons why they should go to an experienced attorney versus kind of one of these companies that not only, it's kind of amazing how much they try to sell you now on extra stuff as you go through that process. But what's your thoughts on the reasons why they would go to an experienced attorney versus one of these other outside companies that just does paperwork basically?
Yeah. Well, first let me follow up on one thing you said. I could draft a 100-page operating agreement with every bell and whistle, every risk factor, but if you pick the wrong partner, or you don't follow securities laws, or you don't treat your partners well, you commit fraud, it's not going to make a difference. So
that goes for marriage too, by the way. So
so I agree. Look, I can draft great documents, but your best liability protection is picking and vetting your partners, operating and conducting yourself in business the correct and ethical way. Sure, things happen, and you want to have great documents, but I totally agree. That the best way is to pick your partners and conduct yourself in business correctly.
Right.
And now I've forgotten your question. So
it was about why go to a specialized attorney like yourself.
So look. LegalZoom has its place. If you want, let's say you've done 12 purchases of small apartments, and you just need an entity form. Maybe you know exactly what you need. Maybe you can go to LegalZoom. But the thing about LegalZoom is they don't offer any advice on, hey, should this entity be managed or managed? Should it have Class A and Class B interest? Should what does it mean if I reduce my fiduciary duties? Can they even add that in? So it's great to have the entity formed and just have a document to have a document, but unless you know exactly what you need and you know exactly what they're going to give you, one size does not fit all. And if I had $1 for every time somebody who formed an entity on LegalZoom came and said, oh, we're having a problem, we have this entity on LegalZoom, my partner doesn't agree with me on what it says, I could retire. But, look, it has its place, right. But I would say generally, it's not appropriate in most circumstances, because I almost know two deals are exactly alike.
Well, and I think too, when you're dealing with, specifically when you're dealing with other people involved in the entity, if it's just you only, then sometimes it may not matter as much, right? But if you're dealing with any other outside party at all involved, LegalZoom does not give you all the right stipulations and go over the buyout clauses and go over every little thing with you to make sure that it's all correct compared to exactly what you want to happen in case there's an issue or having the proper controls and systems set up. So I think that to me is probably the most important piece to understand, just because so many people that I know go to LegalZoom and they go get it done, and then they do the exact same thing you just said. They're like, this doesn't really work, or they don't realize it's not working until there's a problem, and then they realize, oh, we're looking at our operating agreement now, or our attorneys that we had to get are looking at our operating agreement, and now they're like, wow, there's tons of holes in this thing. This is a template. So
yeah, that's right. And again, they're not going to tell you what happens after you form your entity and you get your 10-page template operating agreement. They're not going to tell you what you need to do as far as a bank account or for members, or I don't even know if they're able to put in a buyout clause, and they certainly won't tell you what it is or what it does. They'll say you have to talk to your own attorney about that. So
yeah, there's no education there at all, for sure. So it's absolutely
look, if you're forming your 10th entity, it's exactly the same as the last 9. You just need maybe.
Right. That makes sense. Okay, yeah. Well, thank you so much, Peter. We're over time now. That was absolutely amazing. I think that you gave a really good roundabout knowledge for all these different strategies that people can use for real estate investing versus LLCs and S corps and all of that kind of stuff. How can people reach you if they want to get a hold of you, man?
The best way to reach me is via email. It's pfischer, FISCHER, at Enenstein Law. That's ENENSTEIN law.com. You can also call 310-899-2070, which is the main line. I'm up in San Francisco or LA. Sometimes they'll be able to reach me. Those are the two best ways. You can check out the website, which is www.enensteinlaw, same as the email.com. My bio is up there. Feel free to reach out. I'm always happy to talk to people. People come in and we meet for 15-20 minutes, a quick call or a meeting before starting to charge or do anything. Can't probably give you specific advice on your deal, but at least you'll get a sense of what we do and if we can work together. So we'd be happy to do that.
Cool. And if you guys need to reach me, you guys can email us at invest@ocgproperties.com or go to our website, ocgproperties.com. And you guys can feel free to join us at our Phoebe groups. We have one tomorrow night on investing in promissory notes, so that should be interesting. We have some professional promissory note investors coming in to talk. And if you're this is also recorded, so if you guys need this later on, or email me for the copy, and we'll go from there. Thank you very much, Peter. We appreciate it. That was absolutely great, and we'll talk soon. Thank you guys, everybody.
Have a good night.